Mind Your Business Conversation series. Thanks for joining us. So we're very excited to finally kick this off because we've been discussing this for over a year. So what's this about? A lot of people consider Dubai and the UAE as the land of opportunity, the wild, wild east, where the sky is the limit and business opportunities are there to be grabbed. When you dig a bit deeper though, you'll see that doing business in this region is not as easy as everyone thinks. First of all, it's a drag to set up, and it's very expensive compared to other countries. You have to deal with the question of free zone or mainland. You have to renew your license every year. If you have a bit of budget left, you may consider spending it on protecting your IP, but hey, there are so many other expenses to think of, so you get the picture. Now, despite all this, how can we keep this sense of opportunity alive and help you and each other navigate the system? As there are a lot of expert talks out there already, we wanted to focus on creating an experience sharing community that can learn from each other's mistakes and successes through meaningful open dialogue. Our guest speakers are experienced entrepreneurs and their trusted advisors who will share their side of the story. My name is Janine. I'm a lawyer, optimist, surfer, explorer, founder of Service City International and 2 lean-in circles in Brussels and Dubai. After I spent 10 years at top-tier global law firms, I started working with legal disruptors to make quality legal advice more accessible and more affordable, especially to startups and SMEs. I'm currently working with Argentine Law, a very cool firm that has their values straight. So Ori and Linda, can you tell a bit about yourself?
Okay, my name is Orabezi. I'm the founder of the Scalable CFO, and I founded the company. One of our founding partners is here, Linda Liu, and the other one is Buddy. Unfortunately, couldn't make it. Before starting the Scalable CFO, I'll just give a background of myself. I worked with one of the big 4 firms, audit and accounting firms in South Africa. So I spent half my career doing that, and then I moved to Dubai, and then after spending time with the big 4, I worked with companies, and my main task was to set up and to transform finance department. I consider myself to be a creative stuck in an accountant's body. After leaving corporate, when I started working with companies, I realized I actually really enjoyed and loved working with companies that value innovation and they value people. Enjoyed the idea of getting them to really understand it, to see the importance of financial management and how they can leverage it in their business. Now I'm quite privileged and lucky to be working with an amazing team of people. They make miracles happen, and I give my creative juices get stimulated all the time. What we've just recently done actually is we've launched our portal that connects businesses or business owners with finance professionals. They're looking for people to work with them on a flexible basis, and essentially bringing your big 4 or big tier firm, a consulting firm expertise to small businesses to help them with their finances.
So we're very delighted to introduce you to our guest storytellers. So Nick is the founder and CEO of Twistar, a new type of Android-based Internet of Things mobile device, which is designed for businesses to engage customers in a new and exciting way. He co-founded Twistar more than 2 years ago and has filed his first US and EU patents last year. His quote is #MakeItHappen. We couldn't have found anyone better to start our series with. Haris is not the typical lawyer. He's an electrical engineer and highly experienced international patent lawyer. He has worked for famous corporates like Google and Samsung, as well as tech incubators and tech transfer offices. He's engaged by the UN and the EU to lecture about innovation and IP in emerging markets. But most importantly, you're Nick's lawyer.
Yes, he pays my bills.
So Nick, can you start with sharing your story as an entrepreneur and founder of Twistar? Just start from the beginning, and at which stage were you confronted with the IP question? Did you have sufficient budget at that time, or did you have to prioritize other things? Did you immediately talk to a lawyer and plan out an IP strategy?
So I started Twistar, as you say, just over 2 years ago. I was fortunate enough to have run a startup previously. It was based in the UK and Hong Kong. And so I managed to start that company, grown it over 8 years, sold the company and relocated over to Dubai. I worked for someone else for a little bit, for a couple of years after that, and went back into the workplace. It was exciting, it was good. I was just drawn back into the startup life again. I wanted to do something different, I wanted to go again. So I had the idea for Twistar and promptly told my wife about it, and she said, well, this is wonderful, this is great. I said, yeah, I'm quitting my job tomorrow, I'm going to have a go at this. It's going to be really okay. She said, well, I'm not sure if that's a sensible idea, but I'm not going to try and stop you, so go for it. Do what you can, do what you must. So I went for it at that point and immediately sort of dived into the market with what we were doing. We felt there was an enormous opportunity focused on IoT, voice of the customer, market research, customer feedback, all within that thing to try and bridge this gap. I didn't know at the beginning how big the challenge would be. I didn't know at the beginning what direction it would take, how the hardware would evolve. We've made some amazing progress.
Maybe you should
But I was focused on IP from the very beginning. I was fortunate enough that my wife was an IP lawyer to a certain extent. So I picked her brains on some of the things that I should be thinking about. And I was kind of lucky because a lot of the things that you were able to do as the first stage in a startup, to start building an IP stack, don't necessarily cost that much. You can do the early stages really, really quickly, and even from the first week, 2 weeks, 3 weeks that you're actually running it, if you've got that in your mindset, you can start building a stack and building value to the product that you're building. Twistar is a new type of customer feedback device that helps businesses collect more data from more customers more quickly and easily. We're using things like voice, we're using things like AI to be able to understand and engage people in a new exciting way in the moment for real world businesses.
And at what point did you then talk to Haris?
I initially spoke to Haris and reached out because we were discussing a partnership agreement with an organisation in the US, and at that point Haris stepped in and said, you're doing the wrong thing in terms of engaging with this company. You don't need to be licensing the IP from them, you need to be collaborating on actually developing it. And it was then that we started looking at ways to be able to work with that client, which has then turned into an enormous partnership for us and has saved us a fortune in terms of our development. It really has, literally done it. But then we were able to start talking about other things that we were doing to build more of a structured and official IP stack, things like patents and trademarks and copyrights and these kinds of things, how we were addressing that and how we can take that further forward.
Just to touch base on IP, what is IP? It's intellectual property, and just the four main spectrums is trademarks, copyrights, patents, and then trade secrets. And in many of these contexts, just to if somebody might set up a company one day, copyright is art, creation, software for people who write code. It's the code you create. The two very important things that at least are important in this region are trademarks, right? Whether you start a new company, whether McDonald's, you're franchising, or if you're creating technology, it's patents. So I think anytime somebody starts off with an idea, or you start a startup, you have to think about that. Maybe not spend money on it, but you have to think about an IP posture. Does it require IP? Are people going to steal my quote-unquote idea? But what idea is it? Is it the branding that I'm going to create? Is that the more valuable part? Is it the underlying technology? And then IP can play multiple roles. For example, for Nick, the technology matters, but it's also the packaging, the overall idea, everything coming together, and him going out and pitching it. So I think, not to take away from the technology, but we helped create his IP, or we're working on helping creating that IP, partially to help him keep a hold on that space, but also I think it probably looks good to your investors and everybody else when you go and say, I have a patent.
And so talking about investors, how much importance do they actually?
They want to know. They want to know that it's an issue, that it's something you're thinking about, something that you're addressing. They want to see proof that you're actually going about addressing it. And the thing is, while official lines of IP, you're looking and thinking about the main legal lines, whether it's patents and trademarks and copyrights, but there's so much more in terms of the know-how that you're building within a business. Things like even building a sales database, looking at the contacts, making sure that everything's there, making sure that when you're collecting things like business cards for meetings and stuff like that, that you're not just putting them in a drawer and leaving them, that you're putting them on your sales database, that you're keeping in touch with those people, that you're doing everything that you can. Because every email that you send, every letter that you write, every call that you make, every conversation you have, you're able to take things from that, learnings from those things, and at the end of the day, all of those things add up, and you can start seeing the weight of that knowledge coming further forward to the decisions that you make. We're doing a lot of things, but the more that you can show to investors, the more confidence that they've got in your ability to be able to build the business, build the value proposition, understanding what it takes to get to the next stage, and ultimately invest in your business and go forward.
But how do you showcase that?
Most of the time when it comes to it with seed rounds or pre-seed rounds, more than anything you're dealing with one-to-one relationships. You'll probably be dealing with angel investors or sort of very small VCs who are maybe looking at sort of touching on areas more just to explore those markets. The due diligence at that stage isn't enormous. People are going far more on you, your concept, your project, and what they feel about you. It's far more sort of gut instinct a lot of the time. Things like projections, things like forecasts, they're good. They're things that you need to have, but it's more about who you are and the way that you're going to run a business. It's really going to get investors on the hook at that stage. The moment you start getting to sort of higher seed or Series A, definitely Series B and everything above, you need to start building investor rooms where you're putting all of your IP in one room. You've got all of your contracts, you've got all of your sort of buyer agreements, you've got all of your insurance, everything that's there. So when investors are looking to do their due diligence, they go into those online rooms and they can see everything. Everything's documented, the boxes are ticked, and they can go through the due diligence super quick and super easy.
So they have access to all that information. So they sign an NDA.
Yeah.
But I mean, in terms of enforceability of NDAs, how is that in the region?
Well, I think NDAs anywhere, I think they're very hard to enforce. But signing an NDA kind of preserves your rights legally speaking. So I tell my clients, and if you have an idea, you have a great idea, and you have an IP on it, you want the biggest companies to steal it. Because even if you don't have the money to go for litigation, there's somebody who will fund your litigation. So literally every time I have a client whose ideas get stolen, I'm like, wait 2 years and you'll be a multi-millionaire. So it's not a bad thing generally for people to steal your idea if they're doing it at a large scale. Everybody probably has an Apple or a Samsung phone here. Maybe somebody still has a Nokia, but every time you buy an Apple, Samsung gets about $1.70. Likewise, when you buy a Samsung, Apple gets a little bit of money. So cross-licensing and licensing and somebody stealing your idea is not a bad thing as long as you have your idea protected. Generally speaking, for any startup, if somebody steals your idea, you should thank God. If you're spiritual, do whatever you have to. It's a good thing.
So in terms of registration, what do you typically advise your clients? Because you can register in different places.
Just in terms of IP, it's all kinds of IP. It's a regional registration, whether it's mostly countrywide. In Europe, there's a EP or European Patent Office, and then in the GCC, there's the GCC patent system. Generally speaking, you suggest people to go to their target market. So, for example, if somebody has a brilliant idea of a robotic system or like a neuro whatever transmitter, you can get a patent in Dubai, but there's zero chance that anybody's going to try to create another company which does the same work here. And what a patent or trademark, it prevents you from using that IP. So the biggest target markets, and sometimes it's also a dog and pony show, which we also kind of are doing for Nick as well. And that's where we started off in the US. The US market is the biggest market for most technology, and they have the fastest, most efficient patent system. In this region, honestly, I tell most of my clients, apart from trademarks, not to register patents unless they really have a good reason to. It's very expensive. There's, I think, in one patent case, there's no enforceability. It doesn't create any real value. And again, for a company, either you want to just grow very big, or get acquired, right? So there's the two models. There's a souk model where you just have a big business and somebody comes and acquires you, or it's a huge company like Amazon or any other company, Uber. If you have a great trinket that you make, and they can deploy that technology somewhere else, that patent for them, for you, your company might be worth $1 million. That patent itself might be worth, $50 million for them. So you want to get coverage in the places that it actually has value. So I would just literally think, where's that technology most utilized?
So you said it's very expensive to register here, but I assume it's also a very lengthy process. It takes a long time, right? Because your patent is pending in the US as well.
Yeah, so
last year.
when we actually, with our patent, we got a provisional patent to begin with. So with a provisional patent, what you're basically doing is buying a 1-year term to put a stake in the ground and to prove your concept and idea, where you've got a certain degree of protection over it. You can still designate yourself as patent pending, and you can sort of buy it on the cheap. At the beginning, you just will end up doing a little bit like a brain dump in terms of everything that you know and everything that you could possibly do and put down on paper and getting some patent drawings and everything else. You can do that and you can put that in for a relatively small amount of money compared to going for a full patent, and you can buy a 12-month window. During that 12-month window, you've then got the ability to prove your concept, and you can then flesh out the idea, build out the concepts, and make it something which is genuinely patentable at that stage. That's when you go further forward within that 12 months. You get your paperwork in, and you put it through at that point to go for a full patent, and you move forward to the next stage. So that's kind of what we did. But the timeline for that patent to go from patent pending to be granted,
it could be 2-4 years. You can speed it up by paying extra fees, but regards to cost as well locally, if somebody's actually thinking about patents, the Department of Economic Development gives a 50% subsidy to any entities based in UAE because they want to get the rankings up for innovation. So that is something available to anybody in the UAE if you have a free zone entity or onshore.
Going back to what you first did with your wife being an IP lawyer, so what is it that you did actually to
which she was saying that everything that you're doing, just make sure that you record it. You keep everything there. So everything that you're doing, the work, don't just put it down and leave it. Keep your documents, keep the things that you're drafting. It's things like a sales database, which is one of those things for so long. It's a real hassle when you first start setting up a proper database, using a Zoho, using a HubSpot, doing these things, setting that up, and then laboriously going in and typing in contacts that you already know the details of, and you've got the details on the phone or on an email. You've got to do it and set it up, because all of these kind of things are assets that you're building within the company. And then if you want to bring on board a salesperson, immediately you can just give them that sales database and you can let them go. But these things still work a little bit like with hardware. Prototyping has also got value, and the way that I describe this to other people is that it's a little bit like doing a maths exam. You remember when you were doing a maths exam that even if you got the final answer wrong, if you'd done the workings to get up to that final point, you'd still get some marks in terms of the exam. So the way that I describe it is that if you can show the steps and the stages and the prototypes and the phases and the thought process and what you've actually got to, what you're building up there is a sort of body of knowledge, and that carries an enormous amount of sort of, you know, emotional value and sort of IP to show that thought process when you're putting it in front of businesses. It's not official. We're not talking about patents and trademarks and these kinds of things, but it builds that value of knowledge, and that's stuff that you own. That's a history that you've got. That's something that anyone else who's coming after you is going to have to go through those steps to be able to get to that point. That was the advice that she said.
The only thing I would chime in with that is, I guess kind of hinting at is when you start the process, when you kind of start thinking about IP, what should you do? It literally again comes down to that. If literally you have to look at what your business idea might be. If it has a tech component to it, you have to determine if you're creating some hardware and your business is oriented just around the tech, right? That it's a tech-driven business. Then you have to kind of spend the money and invest and pursue IP very aggressively. If it's a general business idea which utilizes a small technological component, but it's not imperative to the success of the idea of the business, then you can kind of put it on the back burner and kind of slow play it. But if it really comes down to that, I don't know if there's too many UAE-based entities which are purely tech-driven. But on that other hand, if it's a truly true business, then you do have to think about the trademark aspect of it, right? If you're creating a business, anybody's gonna know it as whatever. Like I use the Watchman app. I don't know if anybody else uses that. If they didn't trademark that, somebody else can have a Watchman. So that's something they probably had to create very early in the process. So literally, you have to kind of weigh what your business is and make a decision of what part of the IP is important and when it needs to be pursued.
So with that in mind, we got in pretty early with ours because we felt that it was something from a hardware perspective. We'd done the research, we'd looked at a patent search, we'd had that commissioned and gone through the basic things that were there. The moment we felt like we had something that we could do in terms of really working with, we already had all of our suppliers and the guys we were working with under NDAs, and we were keeping it quite stealthy and quite quiet with the way that we were working at that point. But then we got that stake in the ground in terms of doing that brain dump and getting that provisional patent lodged as the first step, as early as we could really in the process, which sort of bought us that 12-month window. And that's where we were able to start thinking about how we were going to do it for the next stages, the process we'd go through and what we'd need to.
But do you already have to prove the novelty for the provisional one?
Not for the provisional one really, you're more just sort of, it's only I think about $1,500 or $2,000 in terms of some of the things that are there. Haris will probably tell me now it's $5,000 and it's going to take
No, you can actually do it yourself and it'd be $75, $150. You can do it just a data dump. Novelty gets proven in the process of the prosecution, but you should, if you're working on a product, you generally have a good gauge of is it novel or not, but that's literally what you prove through the prosecution, whether it's novel or not, but you don't have to do any searches. Especially in the provisional, I tell everybody it's, do a data dump. I remember the day before the iPhone was released, one of my former firms, I used to work for Apple, and literally, I guess it's 2006, a stack about that big of papers came, which we had to file without analyzing, just literally was, creating that stake in the ground of the product. So.
There's not that many people who know about this, I think, the provisional.
It can be utilized in two ways. One is when you're launching a product and you don't have enough time and you want to get that stake in the ground, and the second is if you're a startup and you don't want to invest aggressively in IP and use a lawyer, you can do all those things, but if you're really tight on a budget, you can just literally do a data dump, read some applications, don't try to write one, but read something and try to figure out, get it in those kind of forms, and just create that so another lawyer comes in a year later when the business has taken off, your idea has been fleshed out, and they can utilize that to actually file a real patent application.
So I totally understand protecting IP. Like you were saying, like investors like to see that, people like to see that. It's also for you, you kind of have that peace of mind of like, oh, we have a patent, so no one can touch us. It's great. Obviously, that's not true. How often is it actually helpful in a case where it does get breached or it does get copied? Like how often is it really actually helpful to have that? Just in my experience, a lot of times when you're a startup, you end up kind of dropping it because it's just not worth exploring. Like somebody maybe bigger than you or maybe well funded or whatever has taken something that you created or even just borrowed an idea from something that you have technically protected, but then you don't end up really being able to.
For us, it was something that we wanted to do. I mean, everything that you're looking to try and do is, but not everything, but a lot of the things as a startup is trying to build defensibility around your product. And if us having a patent and broadcasting that and telling that to people puts off 1, 2, 3 guys that might be coming after me and chasing me with the things there, that's great, that's helpful. That's 3 less startups that I'm going to have to deal with. The other thing is that if some of a bigger companies going after it, as Haris said, it's kind of like happy days. They can run with it in terms of their product. If they win, I win. If I win, I win. So both ways, it just goes that way. But if you do it and you put it in the ground, you own that space at that moment. As long as you've got it drafted in the right way and set up in the right way with enough sort of flexibility around the sort of terms and the structure of what you're doing. And that was something that was really interesting when you start looking at patents and start reading them, because it's quite different from other legal documents in that it's accurate and specific enough to be there, but yet it's vague enough to be able to give a little bit of wiggle room left and right in terms of what it might be and the way that it might be moved and used. It's really, really interesting. It's very different from any other legal documents that I've read before. But it's good to have, and it is really good when you're showing it to other people, because defensibility from a startup perspective is something that you'll be asked about from institutional investors all the time.
Yeah, like we have a utility patent on a physical product.
Yeah.
And that was the first thing that I did was, okay, I'm gonna protect this because it is a novel design and a novel function and all that. But over the course of time, I realized somebody could just change one tiny thing in this and it would become inapplicable. So all of that effort and all that, now every time I release a new product or create a new product, I think a million times before filing a patent. But the first reaction was like, yeah, we need to protect this design. But how protected is it? When it's utility based?
Well, that's partially the art of patent drafting. So I'll give you the America Online. I don't know if you guys know America Online. There was like 56K dial-up and beep, but now they own like Huffington Post, MapQuest, all these things. 2008, their company valuation was down to like $460 million. And my firm, we had their patent portfolio. We ended up analyzing it, all that, and ended up selling just a portfolio for $1.08 billion. So literally the company's valuation was $460, including everything they own, including the IP. It was something that wasn't understood because whoever bought it could utilize that at a much different level. But just from that, and these patents don't exist anymore, but instant messaging, that concept of receiving data from one source, processing it and displaying it to some other source. In probably 1990s, if anybody, all of you are young enough to remember that, that was pretty revolutionary. But now if you think about it, SMS, texting, anything that's happening on your phone is using that technology. Now the patents are not valid anymore, but that technology was very valuable in 2002, 2003. So it's part of that skill set is, when you draft that patent application, it depends what purpose you're doing it for. If you're doing it to stop other people from coming in, then you try to draft it in a broad way that new innovation which may happen or people may make changes, it covers that. Sometimes you do it for, again, the dog and pony show that you can just tell VCs or investors who are not always sophisticated about IP, hey, we have a patent on this, right? And that it's going to be very narrow, it'll be easy to get around. But even in that kind of a scenario, I don't want to talk about litigation, but you can, sue someone. The costs are so expensive that they'll settle for like $100,000, $200,000. So there are ways to play around with it, but to just pull that back, I think for IP or especially patents, there's the defensibility, there's protecting your product and creating market space, right? So if you have a patent on something in Europe, and it's going to be hard for somebody to come in from any other, China or wherever, who has a similar product, because they won't go to you. The bigger companies will be scared to buy from them. And the third is also creating a value for your startup. One of my clients about 3-4 years ago, their yearly revenues were, they had invested a lot of money into it. Their yearly revenues were literally like $200,000, and the investors had spent maybe $3-4 million of their own money. We ended up just selling their IP portfolio at that time to an entity, a multinational based from South Africa actually, for I think it was $13 million. Again, they didn't have any market share, their products weren't doing that great, but their IP for that company was so valuable that just that IP was bought. So it can have a value, it just depends on if it has any applicability. Again, as I was talking about it, if you do find make something which allows for you to track cars better, right? Uber or Careem or Lyft or something might be interested in that technology. For you, your idea may not, if you start an Uber type of company, you may not have market share, but for Uber, that technology may be worth millions. So there's ways to leverage IP, but it's just so nuanced, it's hard to give a specific answer.
So Lane, can you just say what you're doing?
So I have a company called This Toothbrush, and it's a revival of an ancient method of oral hygiene called the miswak. And what we've created, the thing that we've patented, is actually a cutter case. So it's a carrying case, and it cuts, peels, and stores the miswak. The miswak is like a natural branch of a tree. So that's like our signature product, and that's what we have a patent on.
The other interesting thing about what we were doing is that because we spent quite a lot of time refining the product and going through those stages, and so one of the big things when we actually went from the provisional to then filing the full patent is that by that point, because we'd done so much prototyping on the device and because it's so very ergonomically driven, the thing that we found through going through the prototyping is that there is a sweet spot in terms of the size. When you're making a device that's there, like ours is a sort of twist and push type component that's there within this thing, anything that's slightly too big, even like a tiny little bit too big, just feels cumbersome and it just feels totally wrong. And anything too small just feels diddly. And the thing was that when we went through the prototyping and we did this thing again and again and again and again, we just found that it was just this size was the thing, the dimensions were the thing that really were specific. And if we own that space that's there and that shape with the form factor that's there, that's a pretty big stake in the ground. So the ergonomic factor around the design of what we were doing was actually really important. The mechanisms for the other elements, it was just the case that there were so many things through going through those stages and that learning process in terms of building the product, things that just felt right as we went through. Even within that, I feel that even though there would be an option to make it a little bit bigger or this or a funny different shape or something else that's there, if you're distilling it back to the best fit for the product, because we'd spent that time, we've got the best option.
Yeah, so basically, I'm going to start a new startup, so I know that there are already patents over there for that. So how I can go get around them and try to build something like that, but not using their patent so that they can see, I'm a startup, I cannot afford to buy them or anything like that. So how to avoid them and still do my thing? So how is that impossible? I mean, even if it's possible or not. So yeah.
Well, it depends on what field you're dealing with. This is again a very nuanced answer. For example, if you have a startup in the telecom space, there's laws in various countries where you're forced license. So if I start stealing your idea, it's not that I'll have to pay everything I make to you. There's a nominal licensing fee, whether it's 1 cent, 2 cents, whatever it is, or dirham, or whatever the increment of a dirham is. But generally speaking, if you're delving into a field you generally do have a feel of what the competitors are doing, right? If you're delving into any technology, you just don't say, I have a startup idea. You kind of research the competitors. And if you do, you can go on like google.com/patent and do a search for what's out there. But you do have to get a feel for it. But if you're starting out, litigation in patents is so expensive. A litigation can be $1 million, $2 million. So if you're like, a 20, whatever startup, nobody's gonna come after you. By the time they're coming after you, you've probably succeeded already. So that's not a bad thing. So I'm not saying you just go and do what you want to do, but if somebody's trying to sue you, you've done okay. So and then you can do licensing deals and things like that. But if you have a good idea and you're initiative to do it, don't stop because of IP.
So maybe, for example,
Unless it's Twistar's competitor, then stop.
That's it. Stop it. I've got $1 million ready to go.
yeah. So let's suppose we tried to patent back in Pakistan. So what we did is that we made the first mobile ad network for Pakistan. We worked with mobile over there. So yeah, mobile little bit invested. So why they invested? Because we have the patent over there. We said we have patent pending. They said, okay, very good. So if they don't know this money. So later on, what people are using the same idea in Pakistan, but the thinking is different. They say that we are using the same structure, the same modules, but now we are doing for user profiling. So we said managed to do the same thing for ad network, the same structure, the same values, same input data, but now saying no, we are not doing ad network. We are doing user profiling. So I don't know where the gray line is.
So I can tell. I mean, that's a legal question. I can tell you where the lines
He's
are.
going to start charging you.
I might start charging you, but I also work with the intellectual property organization in Pakistan. We can have a later conversation. Their understanding of patents is not the highest. But just generally speaking, it's again depending on, you have to look at what your patents and your language says, and if you have proper claims in it. Is it input of data and output of data? I mean, depending on what kind of terms you use. If you use very specific language, then you have to say that specific language is equivalent to what somebody else is doing, right? It's not the general concept, it's literally what you wrote in there. If you use first data and second data versus like data from input data from a cell phone, it just depends on how broad it is. But that's a very long conversation we can
I
have.
actually had a question. I have two. The first one is quite advanced. You spoke about value. And have you actually made any attempt to try to value your IP? Or even try to sort of see what investors might, or how they might perceive that?
No, because I'm so focused on the product and the business and getting it to the next stage. And at the moment, that's like a 26 hours a day, 8 days a week job already, just doing that to be able to get it going. It's reassuring to know that there's that degree of coverage and that all the time we're working to try and build more products and build more components and take more ownership and sort of, especially with regards to hardware and electronics and these kinds of things. So everyone's looking to try and get to that point, and so we're trying to build our stack through developing or sort of co-developing new electrical components. But in terms of trying to put an actual value figure on it, we've left that fairly open in terms of what it actually is, what it could be. Because we need to prove the value proposition of what we're doing first before the actual product has one. Yes.
It's also a very subjective scale. So, I mean, there is formulas. If you have a product, market share, there's little calculations you can do on licensing fees, and for example, in the medical field. But it's also, again, very subjective, as I was saying, like for one company, a certain IP is worth X amount, and for another company, it's worth Y amount. It's, look at market share, or you look at how big the market is, $30 billion market, if it's something which everybody may be using. So there's no real objective criteria of valuation. It's a very subjective type of skill set. Literally, we've had instances where, or at least I've had instances when I was working as an associate, some client of the firm came, they had an $18 million offer on their IP, and they said, anything else you get, we can do a 50-50 split. I didn't get the 50-50 split, but like I worked over the weekend, and then the partner called, and I was exhausted, and he's like, how much do you think we should ask for? And not out of nowhere, I pulled it out. I was like $30 million. We ended up selling $30 million. It was based on a bit of experience and recognizing what the valuation is, how big that industry is. But it was not a scientific approach to it. It was more of like a gut. That's a reasonable price to ask. This kind of potential, and literally 2 days later it was sold. So it's a very subjective kind of scale. There is some objective criteria you can utilize to evaluate IP to see if it's valuable or not. And you can look at patents to see if they have any real value. But just to say, okay, that patent is worth $2,000 or $20,000. No, it's, give me a patent and I'll analyze, is Apple using it, is Samsung using it, how big the industry is. So it's no real one way, but again, it comes down to what your idea is. I think with Nick's product, it's the patent on that as well, but it's also the branding, the fact that he's wearing his shirt and refuses to take it off, right? But that's the value of the company, right? His brand and his name also has a lot of value. So I imagine trademark is a important aspect of that IP and his know-how.
So as startups, obviously you're limited in funds, and as Nick put it, everything you do in every sector is technically building an IP and a database. At what point do you know when to engage in a lawyer like yourself? And how do you go about it?
You have a lot of conversations with a lot of people, and you try and learn as much as you can, as quick as you can from as many people as possible. And then you try and interpret that in terms of your business, where you are and where you want to be. I was fortunate because I was married to a lawyer who was able to sort of give me some advice.
Very right.
And so it was like, I was lucky and I was fortunate, but it was one of those questions also working within a hardware startup. You get asked a lot more about patents in particular. People want to know. With things like software, with these kind of things, it's a lot more of a sort of open-ended topic around what you're doing to protect your IP. But with hardware, people want to know early. It's often one of the first questions that I get asked. And being able now to nip that in the bud and say, yeah, that's something we've got, that's done. That really made a difference to a lot of conversations, and it just meant that things started on the right foot and that we showed that we were taking steps to be able to do it. But it was, financially, but also time. It takes a lot of time, not just in terms of the legal aspects, in terms of the drafting, but the prep work and the number of people that were involved in actually putting together the designs, the patent drawings, the documentation, all of the other aspects. Like we had all of my other different teams that were working on it. Everyone had a hand in putting together the details for the final patent submission. So it was a lot more than just the legal bits in terms of what it actually cost. But it was something we needed, it was something that I wanted, and it was something that I feel that we will get value from as we go further forward.
And it's a bit of a learning process too. It's not one of those turnkey things you go to someone and say, I want my IP. It really, you have to flush out, develop your strategy, and know your institutional philosophy of why you're getting your IP. Is it marketing? Is it actual use? So it takes a little bit of effort and time, but you can, Google it, use resources. I think there are plenty of, at least in the UAE, not great resources, but there are resources here, even from the government, where they provide you support, whether in terms of knowledge, whether in terms of funding. But I really think it comes down to really actually doing the research and talking to people. The one thing I would suggest if somebody's actually pursuing IP here is to use attorneys, apart from me, not here. there's a great understanding of trademarks and copyrights here, but there's not, because again, there's not much of a tech industry here. So people just don't have a subject matter expertise. And I don't know if when you were looking, what your...
Yeah, we reached out because we wanted to put a stake in the ground in the US. We felt that was going to be our biggest market, but we also felt that was the best value for money in terms of just going for patents. It's enormous. Going after Europe, it's kind of like a country by country matter thing, or you've got an EU patent, which is still a bit questionable about some of the things, how that will be interpreted, the way that it will work, the way that things go. But with the US, it's such an established market. It's really, really good. Works well. The process is efficient. You can go through it. I initially reached out and spoke to people in the States. Haris and I actually met at Jitex, of all places, was one of the things. We were chatting, I was on the Astrolabs stand, sort of getting a free ticket and entrance to Astrolabs courtesy, to Jitex courtesy of Astrolabs. We got chatting then, the timing was right, we met up for a coffee the next week, had a chat, talked it through. Haris gave some great advice in terms of where we were at that stage. And then I think I came back to you about a couple of weeks later. We started looking at the initial contract for the collaboration agreement with the States, and then started the conversations about how we could build an IP strategy and take that further forward.
But I guess the point is, whatever thing you're doing, whatever kind of legal advice, please ensure that whoever's giving you that advice has that actual expertise, not just their firm profile, because that's, at least in this context, IP, that understanding, I have fun to be here, and I've interacted with firms, because initially I was thinking about moving here to work for a firm, and just isn't here. So it's worth fishing for that in the UK, Europe, wherever, but expertise is not here.
The fact that you're an engineer helps.
it does, but it's not just engineering, but I think it's just also like having worked in the US. I was knocking out 30, 50 applications a year. I think in all of the UAE, maybe there's a total 100 applications, and I don't know how many IP attorneys, and they're probably farming that out to Singapore. So they just don't have that skill set to develop that expertise or minimal, I guess, skill set to do it at a global scale.
Where you file and what is the coverage and what is the jurisdiction?
It's based on countries or in some regions, so EPO, but mostly it's U.S., Canada. They all have their own patent regimes. There's no official reciprocity, but if you get a U.S. patent, you're more than likely to get a patent in UK or in Europe as well. But there's certain 6 entities which are kind of tied to each other, and they fast-pace your patent if you get in one of those entities. But if you get it in, Somalia, that may not help you in the U.S. But if you get it in the U.S., that probably helps you in Uganda, I guess.
As an example of that, with the patent that we drafted for the US and submitted there, we were then able to take almost exactly the same drafting and legal terms and take that to the IP lawyer that we were working with in the UK. They were able to take that document with minimal changes, register that and push that through in the US, which meant immediately, it was great value for money to get US and UK, but the UK, where we're registered as a company, has got a really, really good thing called patent box relief. So if you get a UK utility patent, your corporation tax will go from 20% to 10% for the lifetime of the product, which is a really, really good one to have because no one likes to pay tax.
What if two individuals or two entities file in two different places? Both are pending.
The whole concept, there's a first to file, but the metrics of whether you get a patent is not just filing it. Not to get the philosophy of what the patent regime is there, but the patent regime initially is you share something with the world and you get a 20-year exclusive right to it, right? So if you have come up with an amazing drug which cures whatever it cures, you get a 20-year patent on it, so you can make a lot of money on it, but then you share it with the world. That's why normal antibiotics are cheap now.
No, this is when you file. I'm not.
No, but even when you file, my point is there's metrics. Unless you file on the same exact date. I guess that is possible, but then they just look at what's out there. If it wasn't out there, you can technically get. If I'm sitting, in the U.S. and Nick's sitting in the U.K. and we have the exact same idea and we file the exact same patent on this exact same day, we probably will get patents in both those places. But that's very, very rare. And generally, even if it's a one-day difference, the metrics are it has to be novel, it has to be new, it cannot be disclosed by anybody else. And in the US, we have a 1-year time period after your idea that you can share it. If it's, I think in European Patent Office, if you publicize your idea, you lose the right to file a patent on that.
You lose that.
You lose the right, yeah.
So you basically cannot say anything. Let's say you worked on something and it has a novelty, and a few months down the line you realize, okay, actually, I think I should patent it.
Yeah.
So you basically in some parts you cannot actually do that.
You can actually, if you publicize it, in some regions you have up to 1 year from that idea, but that whole concept is the philosophy behind patents or IP, is that you share that idea with the world, and in that exchange you get exclusivity to make money off it.
So in that case, where there's two people that are sort of fighting for the same
Yeah.
IP, and one of them has actually disclosed to someone.
Yeah.
Well,
if it's disclosed and if it's public, then neither can probably get that idea, right? So if I disclose how to make this chair on my website, and then somebody else goes and files a patent on that, nobody will get that patent because I've disclosed how to make that chair. So the whole incentive is to, if you have a great idea, file as soon as possible to share it with the world as quickly as possible.
The R&D and all can take place later. But
R&D can take place later. You can also file provisional applications.
Provisional.
You can file provisional applications. You can also file applications on top of those. So, but the incentive is, for example, Coke couldn't, it's a trade secret, the formula for Coca-Cola. So it's not that you can come up with an idea, sit on that trade secret, and once people find out, then you file a patent. Well, companies do that, and it can work, but purely on a legal metric. And if it's a real litigation, you go and you look for notes. You do discovery. You go through, when did you come up with this idea? We've gone back to the 80s. People looked at people's employment agreements, all these things. So if it's a real litigation, it should be filed in a timely manner. you can continue to do R&D, but you can't do R&D, stop for a year, then go back to it and file it. If it's continuous R&D, you can wait till you have a better idea of what your product is.
As a startup, sometimes you try to trademark your brand or whatever it is, and there's trademark watch out there, and you receive a letter. How serious should you take those letters?
This is non-legal advice. I don't, not too serious. I mean, depending on who it's coming for. But there's a lot of people who just kind of send things out there, and if you have, well, it depends on if you have, it's worth, that's why it's worth filing for your own trademark. It's very expensive in the GCC, I don't know how much it is, like $3,000-4,000. It's ridiculously expensive. But in the US, it's like $130, $270, something like that. If you're using an attorney, it's going to be more, but if you have the time and if you have a startup, somebody can learn how to file a trademark. It's not rocket science. So you should have some kind of trademarks that you registered so you can just kind of throw it back at their face. But most of those cease and desist letters, I think you can ignore, but you don't want to be made an example of. That's the one thing. If you're doing it overtly, if you think it's a bad argument, then you can kind of leave it alone. But if you really are copying somebody's product and they are sending you a letter, then maybe you should consider not copying completely.
Kind of on the flip side of that, how do you assess when it is a valid breach of your trademark without spending a lot of time and effort on it? Like, a lot of times, especially today, like, for example, in design and branding, so much stuff looks the same. It's all like, it's so democratized that it's really easy to maybe accidentally create something that somebody else has created, or it could be on purpose, but how do you assess?
So on the trademark side or on the copyright trademark side? So trademark, again, there's two types of trademarks, right? There's the name, and then there's like the logo.
Yeah, I'm talking like more visuals.
More visuals?
Yeah.
More, I mean, again, but it's so trademarks are very, do you have a trademark or, okay, so like, they're like based on classes, right?
Yeah.
So it's very specific.
Yeah.
If it comes down to, it's very close, but then, like, is there any chance of, there's all these metrics, is there a chance of likelihood of confusion? Is it a similar type of product?
Yeah. Are they representing your
brand? If somebody else is selling like
a
Miswak toothbrush or something, I don't know, right?
A funny story that happened actually, it was a few years ago. So the thing is, the name of the brand is so generic, this toothbrush.
Yeah.
It's
are you gonna give it or is it a secret?
What?
Your brand's name.
That's the name of the toothbrush.
Okay.
This toothbrush.
Okay.
Exactly. So that's the name of the brand. And
you actually got that trademark, or is it like the logo you got?
The logo, yeah. Which is just typographic.
Yeah.
Like there's really nothing there.
Yeah.
So because of that,
Yeah.
and this was obviously designed before I even knew what a trademark was. Because of that, like a few years ago, a friend of mine sent me a picture, and it was Dermalogico, which is one of the biggest skincare brands, had a huge ad that said, "This is not skincare," and our thing was, "This is a toothbrush." That was like.
So in that specific thing, because it's not a word, right? So it would have to be like, "This is a toothbrush." Right? In that exact font.
Exactly.
Right?
So it looked exactly like it.
Yeah.
Because it was the same font, the same color scheme, the same whatever.
But different words.
Different words.
No, but that's the thing. In that.
But the campaign was like the same campaign.
But that see, it's not right. In that, if you have the logo, like literally, it could be words, it could be anything. If it's a logo, actually, they don't have, it's flat. They don't have a brand, right? But it's like. Well, if they had a brand, it literally has to look like that logo because it doesn't matter if it's words or not.
Yeah.
If it's words, right? If it was like, if you got this is a toothbrush or this is a toothbrush, and somebody else had like one letter, this is with a 5 or something, then you can say this is similar.
Yeah.
Or if yours was like red and theirs was like purple or something, you can say it's similar.
Yeah.
But if you have that logo, if I can't read English, for me it's just scribbles, right? Do those scribbles look the same? They probably don't.
Yeah.
All right.
Cool.
Thank you very much.
Fun stuff. Thank you.